Hey everyone, welcome to LawPutra YouTube channel. Myself Khushi, and today we are going to talk about a new topic, that is arbitration award and what it must look like. Now, before going any further, let's quickly have a note or a glance at what its background actually is. So, arbitration, as we all know, is an alternative dispute resolution for settling a dispute with the help of an arbitrator. There are various steps involved in arbitrational proceedings. Now, the major fact that is to be noted down is that an arbitration will usually end with an award. Now, this award is something, this terminology is something that we need to keep a track of. So, before understanding what arbitration award actually is, let us first know that the act which is to be referred here. The act that we will be referring throughout the presentation is Arbitral Award under the Arbitration and Conciliation Act of 1996. Again, before moving any further, I would again like to tell you a quick review of how an arbitration process takes place or what actually happens there. So suppose there are two parties and a dispute has taken place between them. Now, what they would do is that they would hire an arbitral tribunal. Out of that, they expect that either the arbitral tribunal takes a final decision or an interim order that will be valid till the next meeting or the final order has come up. Now, this has also got a limited period of time to be resolved. Suppose if the dispute is not resolved or any sort of award is not, any sort of decision is not reached out within a period of 12 months, so that matter automatically gets closed for that particular arbitration process. So this was the quick review about what actually happens in an arbitration proceeding. Now let us understand what an arbitration award basically is. Before getting into the complex definition of this terminology, let me quickly give you a definition in layman's term. So it is a judgment which is made outside the court, or to be more simpler, it is actually a decision or an order that is to be obeyed by both the parties amongst whom the dispute has taken place. Now let's have a look at the technical definition of it. So it says an arbitration award is a conclusive determination as to the disputes that are put forward before the arbitral tribunal. So this is nothing but what I just explained to you right now. It hears the complete dispute between the parties by giving each reasonable opportunity, and then on the basis of evidences submitted delivers a final decision. Now, this is what an arbitral tribunal is supposed to do. He has to listen to the complete dispute between the parties without any sort of impartiality or injustice in explaining the terms and conditions to each party. In layman terms, it is a judgment made outside the court. That is why it is called as alternative dispute resolution. Okay, note down the word alternative, because it is an alternate method to avoid the court proceedings. Okay, so this is what an arbitration award actually is. Now, this arbitration award has got certain underlying principles. Now, the decision that will be taken by the arbitral tribunal has some provisions for the parties as well as for the arbitral tribunal as well. Now, suppose there arises a decision, a decision has been taken by the arbitral tribunal. Now, there are certain provisions as well, right? Like if the parties are not satisfied with the decision that the arbitral tribunal has come up, then there has to be some provision for challenging it as well, right? So these are some of the principles that actually help the parties in giving them the opportunity to ask for the review of that order, because obviously if you are not satisfied with it, what's the point of going into the alternative dispute resolution method? So the very first question about the underlying principle is that who actually can challenge it. The answer is pretty obvious, that if the parties who are involved in the dispute resolution, only they will have the authority to challenge the arbitration award, because they will be the one on whose terms and condition, or on whom the terms and conditions are going to apply. So they must be satisfied, and they must be satisfied with the fact that if I have been Given I have been issued an award, so I should be satisfied with it. And if not, I can have the authority to challenge it, to challenge the order that has been issued by the arbitral tribunal. So the obvious thing is that only the parties which are a part of the arbitration only have the authority to challenge the award. The second question arises that who has the authority or where the award can be challenged. So it again, the answer is very simple, that it can either be challenged in the district court or in the high court based on the sort of arbitration that has taken place. If it's a domestic arbitration, it will definitely lie under the criteria of the district court. But if it is an international commercial arbitration, it will definitely fall under the authority of the High Court. Now, the third major important question is, what is the timeline or the time by which a challenge against an arbitration award can be raised? So the answer is very technical, that it can start from 3 months, and if not done, if it does not take place in those 3 months, then only an extension of 30 days can be given. So these were some of the underlying principles that needs to be taken care of. Now, the arbitration award are majorly of 4 types, namely final arbitration award, interim, settlement, and additional. These definitions are very obvious and clear. For example, if we have a look at the final arbitration award, it means that it is in accordance with the law, no need of modification to it. It is very simple. The second one is interim arbitration award. As clear from its name, the word interim implies that it will be enforced till the time being. The third one being settlement arbitration award. It actually means that to sort out the matter on their own instead of having it adjudicated by the arbitrator. Now the scenario arises, suppose among the parties between whom the dispute had taken place, they, on the basis of certain terms and conditions amongst themselves only, agree to take an impartial decision on their own. So where arises the need for going to an arbitral tribunal? So obviously they will settle it down on their own. This is what settlement arbitration award is all about. The last one being additional arbitration award. Now let's have a look at the explanation which has been mentioned over here. So it says, when order was given, but later it was found that the certain claims had been submitted were not resolved or adjudicated. Suppose there were a total of 4 disputes or a 4 major matter of concern that were to be resolved by the arbitral tribunal, and only 3 of them were satisfied, and the parties were not satisfied on the decision or the issuance of the 4th order that they wanted to take place in a much modified way. So what they can do is that they can challenge the additional arbitration award. So these were the 4 types of the arbitration award or the decision that was issued by the arbitral tribunal. Next, as I mentioned in the very first slide, that the 2 major topics that we are going to cover in this presentation is what is an arbitration award and what it must look like. Now, by the line, what it must look like, I basically mean what are the necessary requirements that the arbitration award must comprise of. So the very first point is that it must be made by a majority. It must be made by a majority. Now, suppose arbitral tribunal won't be comprising of just single person, right? It can be a group of people. So there arises a requirement that at least if there are 4 people in the arbitral tribunal, then at least 3 of them should take the decision that has to be issued, because then only we will call it a decision that was taken by the majority of people. So this was the very first necessary requirement for an arbitral award to be given to the parties. The second one being that it must be accountable and transparent. What I actually mean by it, that it must be presented in writing, signed and dated. It must be written in the form of a written document. It must be signed and it must be dated on the date on which it was issued. The third point being, the third and fourth are a bit interrelated, because anything which has got a reasoning in it, it automatically becomes legitimate, it becomes logical, and then there is no provision of calling it unclear. So if it comprises of a reason, it automatically becomes a clarified version of the issue. So it must be reasoned and it must not be vague. The fifth point is that it should be capable of being performed. And the sixth point is it's complementary actually. Suppose something you have been asked to do something which is illegal, which is not in accordance with the law of our nation. So obviously you won't be doing it, right? So anything, the issue, the issuance by the arbitral tribunal that has been issued, it definitely has to have an order which can be done, which can be performed, and it should not disobey any sort of law that applies in our nation. So these are the necessary requirements for an arbitration award to be whole, to be true, or in simple terms, it will only be valid if these six major conditions are fully satisfied. So this is what we actually mean by what an arbitration award should look like. Next, as I was previously mentioning, that suppose the order was issued by the arbitral tribunal. However, there are possibilities that the parties are not satisfied with the award that has been given to them. So there is a provision to challenge that award. This is for the benefit of the parties or the people who are involved in the dispute or who have come up with the demand of hiring an arbitral tribunal. But the challenge can only be done on the basis of specific grounds. However, both the questions relating to the law and the fact can be raised. There are a total of two provisions in it, and those two provisions are further classified into three major provisions. The first and second provision are for the appeal. In fact, the third one is also for the appeal, but the third one majorly revolves around the review that can be done by the court itself. Now let's have a look at it. The first section that gives the opportunity to the parties to apply to challenge the award is section number 13. Now, what it actually means, when it is felt that biasness was done, when the parties feel that some sort of biasness, impartiality, injustice in giving them the opportunity to present themselves, to present the evidence in front of the arbitral tribunal, and they are not satisfied with the way they were treated, they can definitely challenge the arbitral award. So, but the major thing that needs to be highlighted is that first appeal has to be made to the arbitral tribunal. AT here means arbitral tribunal. First, you have to go to the arbitral tribunal, and only if even after that you are not satisfied, then only you can go to the court. So this was the first provision that helps you in challenging the arbitral award that was given to you. The second provision or the second section that benefits the parties in order to challenge the arbitral award is the section 16. Now, what it actually comprises of, that if it is found that the arbitral tribunal has overstepped his jurisdiction, then also there arises a possibility that the parties can challenge the award that had been issued to them. Now, the third major important section is section number 34. Now, this is actually for the court when you want a court to review the arbitral award, okay? So what actually it comprises of is that specific grounds for reviewing an award. There are certain set of terms and conditions. The first one being, if you want the award to be reviewed, there has to be these 5 conditions in the award. So the very first thing, if the parties are found to be incapable, suppose the agreement was made with a minor, so there arises a need for a review by the court. Also, if there is any sort of invalid arbitration agreement found to be made, then also the court can review the arbitral award. The third one being, parties not given proper notice about appointment of the proceedings. Fourth point being, awards were given for the disputes that were not even submitted to the arbitral tribunal. Now, let me explain this fact. Suppose you had 4 major problems that you need to be, that you were seeking resolution or resolving of, but the arbitral tribunal jumps onto some other issue and gives decision for that. Now, what would it do? Obviously, it won't satisfy the needs of the parties, right? So this is also, if even if this thing happens, then also the parties can challenge the arbitral award by asking the court to review the arbitral award. And the fifth point being that award was not in accordance with necessary requirements. Partiality was done. It is again a very important thing being highlighted again and again. If the arbitral tribunal is found to be doing impartiality or any sort of injustice to any of the parties, then also the arbitral award can be challenged. Now, there are a certain set of provisions also which the court can look at its own motion. So there are just two major things. The first one being that the subject matter cannot be resolved as it is incapable of settlement by arbitration, or if it contradicts the public policy of India, then also the court can take the matter into its own hands. Now, suppose you have already challenged the arbitration award. Now, what are the consequences of it, repercussions of it? So there are four major repercussions that can happen. For example, the first one being set aside. The court just simply sets aside whatever arbitration award you had challenged. The second one being that it confirms the arbitration award. Suppose you took it and you took the award to the court and the court read it, reviewed it, and it found out that it is okay. Nothing, there is no problem with it. So what the court actually does is that it confirms the arbitration award. The third one being modification. If the court finds out that the arbitration award on which the claim was done, if it needs any sort of modification, then the court in its process of reviewing will modify it. And the fourth possibility is that if the order that was passed, the arbitration award was passed, it's up to the mark, then also there is a possibility then the court will remit you back to the arbitral tribunal. So these are the four major consequences or the four major ways in which the court can act. Now, the last thing is what actually happens in the enforcement, or what are the things that needs to be taken care of while enforcing this act of arbitration and conciliation. So the only major thing that needs to be taken care of is that it has to take place under the provisions of the Code of Civil Procedure 1908 in the same manner as if it were a decree of court. I guess it was a bit self-explanatory, and that was all for today's presentation. So thank you so much, and yeah, have a good day.